Malhotra. I am here as a ILA young scholar, perhaps I'm the youngest on the panel as well. I'm quite honored and delighted to present this paper, which will also become a part of my LLM dissertation at SOAS, where I will read as the Felix Scholar, and particularly today being a delightful day as I received my official LLM confirmation letter for the Felix. So today is a auspicious day and also a very happy day, not only for me but also my father, who I have the honor and delight of sharing this platform with. Let me start by going to poetry, as we often tend to do when reading about what is essentially a family. And there are two poems which you see on your screen here. By the way, the slides are also descriptive and also illustrative of what we'll be covering. Since this is speaking about Indian law and how it reacts to international law and vice versa, thereby understood as foreign relations law, you'll see the cases, citations also referred for further reflection. But coming to the topic more specifically, our presentation will cover child custody as the vexed question of cross-border international parental-child removal. We're not finding any legislative grounds in the Indian legal system, which is then up to the Indian courts and the precedent which they set in reaction to the case and the factual matrix which they deal with. In the face of this, India is not a signatory to the Hague Convention on Civil Aspects of Child Abduction, which has been accepted by almost 110 states. Therefore, the wrongful removal and retention of a child by a parent defies recognition and the acceptance under Indian codified law, even though it is an offense internationally. So this is how perhaps we, as presenting an Indian perspective, react to the topic that we wish to cover. As I've already covered, India is not a part of the convention, therefore not a part of the connection. If it's not a part of the connection, it cannot utilize the cases or the precedent that the convention sets. Therefore, the question really is over the uncertainty whether the child will be returned to the habitual residence, and the innocent child is therefore the one who suffers in such situations. The concept of child abduction requires further stress as well. That is because it is not defined in the Indian legal legislative systems of which other countries are part of. This question comes back again and again and will be highlighted later as well. But in the face of this, India also does not have a unified codified system of laws which are applicable to all citizens. We, as a result, utilize a system which differentiates on religion and not on, let's say, you just being a national to the country. Therefore, the laws relevant are really scattered, and words more familiar to public international law is fragmented. So it's a fragmented system which you have to deal with, and therefore you see sections which are relevant and have been highlighted over here. But the crux really is, and you see it on the slide, but I'd like to emphasize it by saying that interparental, intra-country or inter-country adoption and child removal of parents where a country is not a statutory country which does not recognize this as an offense. In a country like India, the jurisprudence of the subject of international parental child removal in India is evolved through decisions of litigated cases involving guardianship and custody issues being periodically expounded by the courts. This really remains the vexed question which needs to be answered as well. So the removed child in the law, which is also the central thesis of the work which is carried out by the firm, focuses on this practice, and the corpus of 30 million Indians residing abroad in various countries, specifically North American and Western European countries, is where these children are really found, essentially where these families are found. And since the children are young, they do not have the legal competence, emotional and also psychological understanding to do this. So this becomes an interesting dissertation topic to study the psychological aspects of these children who cannot come to a conclusion on their own. Now, having established an understanding of the Indian system, I'd like to spend a few moments to share the international corpus of conventions relevant to this, and to which India has reacted in terms of adopting legislation, relevant legislation on these counts. And this, as you see on your screens, India is a party to the International Convention on Rights of the Child of 1989. It is also a party to the Convention on Protection of Children in Cooperation in Respects of Inter-Country Adoption. They have also enacted legislations which protect and have imbibed and also created Indian law. So ratification has gone a step further. It's also become Indian law as it has adopted it and enveloped it in its legal system as well. This, of course, has also gone through change and is become a part of the Indian system. And just to move on from that, there are obviously changes also, amendments also to the rules of these acts, which suggest that these are actively not only used but also reflected upon and changed. The codified laws have also been something that India has inherited from its former colonizer, which is almost always reflected as a vestige of the empire, and also obviously and always looked in a bad light. But this suggests of how important and empowering the British Empire was for a country like India. But what is sad and also true in this circumstance has been the lethargic approach of the Indian government and the parliament, more specifically. Government and parliament, may I say, because of the child custody issues between parents, are thus determined by the Guardians and Ward Act, which is a 130-year-old act without any amendment, without any movement. A movement and amendments have been made to the Juvenile Justice Act, but not to the Guardians and Ward Act. And upon the GWA, which is the Guardian and Ward Act, upon a natural parent wanting to be declared as an exhaustive guardian to his own natural born child, is something which has always remained relevant. Moving further, but staying with the theme of incorporating international law into domestic legislation, as I had already suggested, the JJ Act, which is the Juvenile Justice Act, has been created, but there remain challenges to this as well. But let me just say that this signifies the visibility of the UNCRC in a motivating amendment to the Indian statutes to incorporate these international provisions and conventions, as to also offer a sort of understanding of the Indian courts and also the parliament vis-a-vis international conventions. This also suggests complicity to international law and also reflects in the topic which this panel is supposed to cover. Now, I also reflect here on conventional remedies, and I've been rather intentional with titling it as conventional remedies, as to suggest practices which are natural and organic, but also to reflect how conventions have been understood. On the first two, you see those two cases listed, but what I just want to offer with these cases is to reflect the implementation of a habeas corpus for seeking the implementation of child rights, where the parents are fighting over the custody of their offspring related to the Supreme Court of India. That was covered in the first case. The second case reflects upon an English and American law of their Supreme Courts, and how the Indian Supreme Court has reacted to that by suggesting that the basis of issuance of a habeas corpus in a child custody case is not conducive or to be understood as illegal detention. What this practice, at least by the Indian courts, reflects is, and as you can see on your screens as well, invoking the writ of habeas corpus, which is essentially to present the body before the courts within a time span of 24 hours by a non-resident parent for child custody on strengthening a foreign court custody order, is the only efficacious, speedy and effective remedy, since the minor ordinarily resides abroad, but there is no bar of jurisdiction under the GWA for a guardianship petition before a guardian judge in the Indian courts. Now, as a response to this, what has been integral and also quite path-breaking has been the complicity of courts, and the complicity of courts further watered down into the utility of mirror orders. What mirror orders is essentially, as was laid down in the case of Dr. Navteej Singh and the state of NCT, suggests a condition and a precedent for directing the return of the mother along with the two children to the United States of America. The Delhi High Courts had directed the father to move to the US coast to set aside the US court order, which essentially, as you see on your screens, was to implement the foreign order into the domestic systems as a way to propagate the complicity between courts. And to further this, I'd just also like to share that the minor child was to find, the wife was to find a suitable job and restart her professional career. So that's the length to which the courts went to suggest the harmonization of the family after a bitter dispute. And the front of this, let me also just add that the courts also went as far as to give fresh US court orders for the children to remain within the custody of the mother, and the US courts directed that the mother will return immediately to the minor child, who will remain in the custody of the mother, with the father having reasonable interim visitations. The US court also approved the affidavit of undertaking of the father, confirming his conduct of compliance with the directions of the Delhi court in the judgment, which is now listed above as well. Now the family lives together, and the mother has returned to the United States in 2001 in month June. There is still deliberation between the final verdict, but at least the family in some sense is together. But what's this bricolage, or at least this kaleidoscopic perspective of the Indian courts is centered around is the best interest of the child. Now, the best interest of the child, in the absence of an in the absence of a convention which India has adopted, really changes based on the factual matrix. And I cannot stress upon this enough. But in the interest of at least understanding what this essentially means, let me just reflect on a case which tries to do this, as the justices try to understand what this essentially means. And you can see it on your slides, therefore I will not read it. But let me just say that the court, in its wisdom, shattered the glass ceiling of gender preferences and provided neutrality to the parents on the welfare of the child principles. And that perhaps remains the most key development to which this jurisprudence suggests. I will close, but I would like to offer one last reflection, which was laid down in 2017 by Justice A.K. Sikri in the case of Vivek Singh and Romani Singh, which discussed a different aspect, a sort of an aspect of child psychology and the after effect of how this plays out in this bitter dispute between parents plays out in the child, and more specifically what Justice Sikri suggested as the parental alienation syndrome, and how it essentially affects the child and his mental makeup. And I started with poetry, and I should perhaps also end with poetry by saying that the prophecy of Wordsworth, which we saw on our screen, as we saw on the first screen, resounds, reverberates, and echoes, resonating that the child is the father of the man. This vibrant jurisprudence has also evolved from the focus of the courts to evolving law, interpreting the UNCRC and the JJ Act. Consequently, it has also led the Indian courts directing parties to obtain mirror orders as a possible and plausible situation. Let me just end by saying what you also see on your screens as a sort of conclusory note, an analytical or an observatory note, which suggests to finding the alternate solutions for returning of the removed child from till India signs the Hague Convention is an offshoot of protecting the best interest of the child secured under the UNCRC, aided by principles of comity to court, determination of the best interest by jurisdiction of closet contracts, succored found in law enacted by UNCRC umbrella. To carry this presentation forward, I'd now like to invite Mr. Anil Malhotra. Sir.
Good afternoon, everybody. Honorable panel members, people gathered together. I pick up the thread from where the my co-speaker has left. But just to first fill you in on the scenario of what we are looking at. India is a home to 1.3 billion Indians, 32 million of whom live in 208 countries abroad. India itself is huge territorially, 3.28 million square kilometers. Now, the fact that so many people live abroad has generated a crop of inter-country disputes in the marital regime. It starts from marriage, divorce, property division, maintenance, alimony, child abduction, surrogacy, adoptions. So the arena of disputes have grown multifold. Where is the dilemma? Where is the problem? The problem is statutory laws made in India by the English for us and which were carried forward by us have either not been amended or have either not been changed. For a very simple example, the Guardian and Wards Act is of 1890. It's horribly outmoded. It doesn't look at concepts of shared parenting and divided custody. So we have an issue on family law problems starting from the home. I will come to the topic of marriages and divorces, but it is this proposition of a lack of codified statutory law in India, which is not at pace with international laws, makes the wedge deeper, and therefore the requirement of international conventions to fill in the gap is becoming omnipotent and of great significance. We signed in India the United Nations Convention on the Rights of the Child, and as a step pursuant thereto, we brought in an amendment to a lot of our laws for the welfare and the betterment of the child. But we have not signed the Hague Convention on Civil Aspects of International Child Abduction 1980. We have signed the Adoption Convention of 1993. There is no convention on surrogacy, so nothing has taken place. So it is in this corpus of parallel adjudication of disputes in two jurisdictions between the same parties, the couple, that the need for an international convention to fill in the gap and apply a uniform law so that the matter can be resolved is becoming of immense importance. In the previous session held in Roma 2, I raised this question. I said the distinction between public law and private international law is now disappearing. Issues in private international law are becoming judgments in rem, not in personam anymore. If there is an issue of parentage, nationality or citizenship in surrogacy, it involves everybody. If there is a formula for return of children, it concerns everybody. So it is what we have graduated to, as I was discussing with John, we are going into an international family law, or we are probably looking at a public international family law. So it is in this context that international conventions, which is the subject which the theme of this session is of increasingly great importance. Now I developed my proposition further with my co-speaker just left. We have been making attempts to sign the Hague Convention, but there is a very strong resistance from women's groups and pressure groups that Indian women will be subjected to domestic violence and lack of support when they go abroad. So Government of India committee was constituted, I was part of it. It is called the Bindal Committee. It's a 2-volume report. We have suggested a bill in which we recognize interparental child removal as an offence on the parallel lines of the Hague Convention. The bill has yet to see the Parliament, so it is a step forward in that direction. But then let us understand where we have done well. And that is where I will take the example home to show that what we can do if we were to follow conventions. Now, the Convention on Protection of Children and Cooperation in respect of inter-country adoption 1993, commonly known as the Adoption Convention, has done wonders in India. India has over 30 million orphan children. Trafficking of children, sale of children, pedophiles, abusers was enormous in the 80s. So 1984, 1986 and 1987, three judgments of the Supreme Court saw the Supreme Court saying we need to put a system in place. So we created an administrative body, Central Adoption Resource Agency. Then after signing the UNCRC and the best interest of the child coming in, we brought in a number of laws. We have the Protection of Children Against Sexual Offences Act. We have the Right to Compulsory Education of Children Act. We have amended the Juvenile Justice Care and Protection of Children Act of 86 in 2000 and 2015. So we now have incorporated the UNCRC in our statutes, and we are using the definition of the best interest of the child in these litigations. I, as a practitioner, have been arguing before the Supreme Court of India that the best interest of the child is a concept not defined in any law in India. Child removal is not found as a wrong or an offence anywhere in India. So because child removal is not recognized as an offence or a wrong in India, there is no remedy. Unlike the European, American and Canadian jurisdictions where child removal is identified as wrong under the convention and is therefore there is a recourse in law. Now India does not have a recourse, so I have to file a writ of habeas corpus, which is equivalent to the English writ, which we got, and we follow the English and the American principles that this writ is issued in the best interest of the child, with the court as parents portrayed, the guardian of the child. So this is a concept which we use for return of children, but this is only an ad hoc patchwork. After having convinced the Supreme Court of India in taking up the definition of the best interest of the child from the Juvenile Justice Act, coming from the UNCRC, I have further worked on a mirror order formula. If children are not to go back, on the welfare principle, let the Indian court order be mirrored. So in my first matter, which I was able to prevail over with the Supreme Court, I convinced the court that if I was to get the Indian court order mirrored in the US, the children would go back. It worked. So we are moving a step forward. But then, what have we done in the matter of adoptions? Now, because adoptions was a very, very urgent, dire need litigative area, we looked at the UNCRC seriously. The UNCRC says that the family is the fundamental group of society for the child. A child has an inherent right to life. This is something which we get from the European Convention. There is a right to family life. So child has a right to a name, parent and nationality. Identity should not be separated from his parents, should be reunified, and the right of the child to grow up in a family environment. So when we brought in the Adoption Convention, we looked at things of reorganizing inter-country adoptions, designating central authorities, making eligibility reports, and 30 million orphan children now are in a system whereby adoptions take place. This is all thanks to the Adoption Convention. So how good is an international convention in a domestic law? The living example is India. Huge numbers territorially, huge size, massive issues, but a system has fallen in place. So you have Carring's online portal in which you register wherever you are. You are judged by the country in which or the central authority in the country in which you register. A home study report is made, you are matched, and once you are matched, You are given your rating or seniority in India. You are matched and you are given a child. You go and have a look at the child. They will make a home study again. If all goes well, you get an adoption order. Kara gives you an NOC and the child goes out. So a system has fallen into place. And it is because of the convention and because of a central authority taking care of another central authority and the working going on backwards and forwards. So this being the process, this has now fallen in place smoothly. Now let us come to something which came as a fallout of tough procedures of adoption, surrogacy. India was the first country to push surrogacy commercially in the international market. The guidelines of the agency of the Government of India, which floated these propositions, in 1995 permitted it to go on for a long time, and everybody, commercial surrogacy was recognized. Anybody and came from anywhere, he could do commercial surrogacy. The first case was baby Manji Yamada, a Japanese case in which a couple commissioned surrogacy in India. They were divorced when the child was born. The mother didn't want the child. The man could not take the girl child because India did not allow that procedure of a man taking a girl child. So he brought in his mother, Emiko Yamada, from Japan. And she petitioned the Supreme Court of India, and the child was permitted to be taken out by a process of adoption. Then came the German case of Jan Balaz. This was a German couple, Nicholas and Fraud, and they commissioned a surrogacy. Children were born, riots took place in the state of Gujarat. They petitioned the High Court. The High Court permitted them to take the children out, but the High Court in India gave Indian nationality to the children because the children were born to an Indian surrogate mother. Now, as a backlash of that, the Government of India challenged the decision of the Supreme Court and said these are German children. You can't give them Indian nationality. So that issue is still pending before the Supreme Court, but the Supreme Court permitted the children to be taken out by a process of adoption. Matter resolved. Then came Baby Emperor's case. A baby is born in Hyderabad to a Jamaican mother and her American husband, whose sperm she brings in a cryogenic jar because he has aerophobia. She finds a surrogate and she also finds an egg donor, and a child is born to her. Now when she applies for a passport, the passport officer says, I cannot give you a birth certificate because your DNA is not in this child. So she says, what can I do? My husband cannot come. So she keeps going to the passport office every day. Ultimately, one day she leaves the baby on his table and says, you keep it, it's yours. So the poor passport officer was left with no choice but to give him an emergency travel document to leave the country. Now these are all ad hoc solutions. This is locally within India. Let us see what has happened in Ukraine. Ukraine was the only country where commercial surrogacy was flourishing. From 10,000 euros to 50,000 euros, you could get a package depending on the quality of medical services and other facilities which you could get. Came the war. It is reported by New York Times that 500 children were found in bunkers with nurses looking after the children. Because until their parentage is identified, the children can't go out. Now these are situations created by law, which is not private international law. I think it is public international law. It involves nations. It involves segments. So in this scenario, I think conferences like this and people who are looking into, academics who are looking strongly into issues like this, need to put their heads together and see, is private international law now international family law, or is it publico-private international law? I leave it to the wisdom of the conference organizers to dig out a phrase. Thank you.
Thank you so much.